was just picturing 10 additional people not showing up for this, but I'm all happy. I'm happy so many of you are here, and I want to sort of start by a little bit taking the pulse of the people in the room. So my first question is, first I'm wondering if you can hear me without the microphone. Can you? All right. If not, let me know and I'll retreat to the microphone. How many of you would say that you were reasonably knowledgeable about what's going on with developments in the whole issue of same-sex marriage? Reasonably knowledgeable. All right. How many think I know a little bit? How many think I really don't know much at all? All right. So, okay. So it's one of those things where unless you really are immersed in it, unless you really are following it because it's sort of the most important thing you have to do, there are developments happening sort of so quickly that it really is difficult to keep track of. And I think what I'd like to do today is give you a little bit of a sense of what's going on, and then maybe tie it into some broader questions about how we look at marriage more generally. Because I think the same-sex marriage debate, in a way, has given us an opportunity to think more broadly about these questions of marriage. But the paradox is, from my perspective, that it really hasn't done that so effectively. So we hear a lot about the issues of whether same-sex couples should be able to marry, and not as much about the broader issues of marriage more generally that I think this whole debate sort of invites and really makes us have. Okay? So let me start by giving you a little bit of background, and this really is for people who are not so knowledgeable about what's going on, a little bit of a background about how we got here. All right, and it begins back in the 1970s, and I won't be as long-winded as you think I'm going to be. So it begins back in the 1970s when there were 3 different cases brought by same-sex couples that got as far as state Supreme Courts in which they were challenging those states' exclusions of same-sex couples from marriage. And those states were Washington, Minnesota, and Kentucky. And all of those challenges were spectacularly unsuccessful. Right? In fact, the state Supreme Courts didn't really know what to do with these cases, and sort of sputtered and said things like, "Well, marriage, just means the union of one man and one woman," and didn't really sort of excavate too deeply into what was going on. So I think, those were cases that were not shepherded through by advocacy groups. Right? Those were cases that were simply do-it-yourself cases by litigants who really felt like they had some kind of a point to make. I don't think they really expected to be successful. What might be surprising is how not only were they unsuccessful, but the backlash that they suffered, right? So some of them lost their jobs because obviously by filing this lawsuit they had to come out. All right, and this was an era where really no state had any kind of protection for people based on sexual orientation. So if their employers didn't like the fact that they had brought the suit, they could just fire them, and this happened to many of those litigants. So fast forward to 1990s when a case is brought in Hawaii, all right, by another same-sex couple. And originally, again, it was just brought by a few couples and a local attorney, no real involvement by advocacy. I won't get into all the details, but the case gets to the state Supreme Court, and the state Supreme Court says, if you're talking about excluding people from the institution of marriage because they're of the same sex, that's sex bias, all right? And under the Hawaii state constitution, there's protection against people being treated differently because of their sex. So you're treating a 2-male unit or a 2-woman unit differently than you would treat an opposite-sex unit, and therefore that's a kind of sex bias. And therefore, we're going to send this back to the lower court for them to conduct a trial using that higher standard, okay? And the case goes down. The trial court finds that the state could not permissibly keep same-sex couples from marrying, and then the case is going back up to the Supreme Court, okay? This creates a panic of sorts in the U.S. Congress, and this is why the Hawaii story is so important. So in 1996, right, fearful that this export of gay marriage would become as popular as pineapples and just as unstoppable, they passed the Defense of Marriage Act. And the Defense of Marriage Act really has 2 central provisions. Well, really, it's only 2 substantive provisions. So one of them says that and this was sort of the part that was inspired by what was happening in Hawaii, says that no state need recognize a same-sex marriage performed or celebrated in any other state, okay? Now, for reasons I won't get too deeply into, that's already possible for states to do under a public policy exception to the full faith and credit clause. So full faith and credit clause of the Constitution generally requires that states respect the judgments, right, of other states, but there's an exception built in for where the state feels that it would offend a strong public policy. So the states already had a mechanism for stopping same-sex marriage from coming into their own state.